I think we will get started. If I could have your attention, please. Thank you. I could stand up, but then I won't be close enough to the microphone, so I'll have to stay sitting down for the moment. So welcome, everyone. Thank you so much for coming. Welcome to the launch of Ecocide Law Advisory and the presentation of the Manual on the National Criminalisation of Ecocide. My name's Kate Mackintosh. I am the Executive Director of the UCLA Law Promise Institute Europe, and along with my colleague Richard Rogers, who you'll be hearing from soon, the co-founder of Ecocide Law Advisory. So Ecocide as a topic has moved from the margins to the centre of conversations about protecting the environment in a really short period of time. And many of our speakers here today have been part of that movement. Most recently, and of particular relevance for our gathering today, of course, the European Union has revised its Environmental Crime Directive and has issued a new one outlining acts which have to be criminalised by member states of the European Union. When those acts have particularly egregious or catastrophic results, they constitute qualified or aggravated offences. I can try. How's that, Wouter? Yeah. So when the acts are particularly egregious, their consequences, they are qualified offences. And these, in the words of the directive, they need to be punished with higher penalties, and they include conduct comparable to ecocide, which is already covered by the law of certain member states and which is being discussed in international fora. So it's these qualified offences, which include conduct comparable to ecocide, that the manual that we'll be talking about later seeks to address. And in this context, I'm really delighted to introduce our first keynote speaker, Marie Toussaint, member of the European Parliament and Vice President of the Greens and European Free Alliance Group. Marie's efforts were really critical to this directive being adopted and to ecocide being included in the directive, and she continues to lead efforts at the EU level to protect the environment. Marie's joining us from Strasbourg, where the EU Parliament is in plenary session this week, so we're particularly grateful to her for making the time. Marie, over to you.
Hello, Kate. Can you hear me correctly?
Can hear you perfectly.
That's fine. Super great. Thank you, and thank you for this very nice introduction. I think we're continuing very good cooperation that we've led for a lot of time, and that's a bit actually why and where I want to begin. My speech. Hello to everyone, first of all, and thanks a lot for being so many to be here and work on making Ecocide a reality throughout the planet and a very large number of member states. But if I'm here, it's because I've managed to do something great for the European Union. But I want to begin by saying I wouldn't have managed to get there if it wasn't for the very strong and deep cooperation that we've had globally with lawyers and civil society, and especially with Richard. So I really want to thank you for this huge work and your advice and legal contributions have always been of the greatest value. So really thanks a lot for that. It's really nice to be here at the first Ecocide Law Advisory, actually. That will be absolutely essential as we need it in the European Parliament to work on this law, but to ensure that Ecocide is recognized globally. So we needed this manual on the national criminalization of Ecocide, and we're really happy that we get there. Of course, this is linked with how the work that we've done in the European Parliament is going to be implemented also in the member states, which is absolutely essential. And there are still some pieces that will need to be underlined so that we get the best laws possible at national level. So I really welcome the work that has been done under the publication of this manual, also the initiatives that have taken place since the adoption of the directive. And I know that Lemmerhan is with you today, with us today. and is one of the first members of the International Alliance of Parliamentarians against Ecocide that we created, and is keeping on working. So we really need those kind of champions here. And I would also like, and then I end up with the thanking, and I'm sorry it's a bit long, but there's a lot of people to thank. To thank Fausto Pocar for his work with the European Law Institute, because we've also been really in need of their work. And I also want to thank Marie Toussaint from France, from Notre Apparatus, was also really been a great ally. So now you asked me to come not only to thank people, but to talk about the need of Ecocide laws. I think you already know a lot, so I will make it the shortest possible. But right now we are facing an environmental collapse. Seven out of nine of the planetary boundaries are being crossed, and we still don't have the ecological law that we need to ensure that the crossing of those planetary boundaries are being prevented, are being sanctioned, and as a result don't happen. We live in a world where a lot of big companies are attacking on nature, and of course human health and social rights, with while being unpunished for it, because the liability is not there, civil or penal liability. And we still have a lot of work to do, despite the adoption of the directive on the penal side, but we still have a lot to do on the civil side to ensure that we can block those who really want to attack the planet. As for now, and even with a restricted approach of what is environmental crime, environmental crime has become a very important global issue. Just to give you some numbers, if you don't know, but environmental crime has become at the global level as lucrative as the drug traffic, of which we talk about every day. And we talk quite less about environmental crime. So we really need to tackle this big issue, because this is also a security issue. And I think that what we hear, for instance, from Donald Trump to get access to the earth minerals from Ukraine is another sign of this. Environmental crime are still really much ongoing in the world, and the lucrativity of the sectors and the crimes that are committed, environmental crimes that are committing, are still growing by 5 to 7% a year. This is why when I got to the European Parliament, and also with the strength that gave my involvement in civil society before, I really wanted to get this law on ecocide in EU law. We've been working a lot. I don't know if you remember that. It seems like a decade ago. It was only 5 years ago. But in 2018, 2019, there was such a strong push from civil society to act in favor of climate and the environment. And we got the biggest green group in the European Parliament, and we got the Green Deal as a program, as a compass for the European Commission work. So we've been working on some of those issues that I told you about, civil liability, also regarding environmental norms, not reaching a change in legislation, but working on it. We have managed to get more transparency for the companies, also to get due diligence legislation to be adopted. All of this is now put into question, and we're quite happy because ECD, as for now, the environmental crime that has been protected from the threats of the right and the far right, but also from the lobby. So we hope that there's not going to be a step back on this legislation. But of course, this legislation is not yet working. So that's really where we need to focus our attention now, and to ensure that this is translated to the best way possible at national level. One of the issues that we've seen, maybe Italy is not really in case not really concerned here, but the rest of the member states. One of the big issues that we've been working on is the definition of unlawful. As you know, companies don't often, if not never, damage the environment because they want to damage the environment. And on this intentional aspect, we need to have a lot of work. But one step more is to say that most often they are protected because the laws authorize them to act in the way they do. So when there is a huge impact on natural elements or on health, they're protected because the laws didn't forbid them to develop this kind of activity. This is why we've been working quite thoroughly in the European Parliament and with the European Commission to broaden the definition of conduct that can be considered unlawful under the directive in order to reach out, more general understanding of criminal liability at global level. And I want to say, of course, this is a really European approach here, but this needs to be taken into consideration while working on the transposition of the directive in the different national laws. What we did to reach this goal is to say that when being in possession of an authorization, the criminal liability should not be excused if the authorization is manifestly contrary to other rules and principles, and especially the Article 191 TFEU that says that the European Union has a goal to protect the environment and our good conditions of living. So this is how we did it here, and this is going to be one of the main focus, I think, in the national areas. And I say this as well as an answer to the question, why is the recognition of ecocide so much needed? It's because for now we have a lot of obstacles to the recognition of liability when it comes to environmental damage. Maybe just a few more words, and then I think I will leave the floor go on. But we really insisted on bettering the definition of environmental crimes and keeping ecocide apart. And in order to ensure that this is really considered as one of the gravest crimes, also going with the sanctions. Sanctions in Europe are still quite limited when it comes to companies, but we've been going in that direction, and this I think needs to be also really safeguarded. So that's what we've been working as for now. And of course, from the European Parliament, we will keep on I don't know, monitoring. It's a European global world as well, but monitoring what's happening in the ground. And we're still available for any one of you to put pressure on governments, to mobilize the society, to come with legal advice on this. And we will also be there when the time is needed to evaluate what has happened in the different national contexts. And just to end up with this, but while working on all of this, we've worked a lot with police, European police, and we've worked a lot also with lawyers, would be also magistrates, and this has been quite valuable, and this is the course that we need to continue to take. So again, thank you to everyone. Thank you for this manual. Thank you for this workshop. And have very nice rest of conference.
Thank you so much, Marie. And Marie, I know you have to rush back to your debate. So thank you very much for taking the time to come out and join us. Yeah, Marie Toussaint, everyone. Thank you. Okay, so now we can come back into the room, and now I'd like to hand over to my close collaborator and co-founder of Ecocide Law Advisory, Richard Rogers. Richard is also Executive Director of Climate Council, and he was the Deputy Co-Chair of the Independent Expert Panel for the legal definition of ecocide. And Richard is going to tell us about Ecocide Law Advisory. Richard.
Yes, thanks, Kate. And thanks everyone for coming. I'll spend the first 10 minutes or so talking about this new initiative, Ecocide Law Advisory, how it came about, why we think it's important. I'll talk about some of the projects that we've done so far, and also what we have planned for the future. So just so we're on the same page in terms of what ecocide means, there is, of course, no single definition of ecocide yet. There's plenty of variations, both in the proposals and in the laws that have been adopted. But I think everyone tends to agree that what we're talking about is the most serious examples of environmental harm that cannot be justified. Of course, protecting the environment through law is not a new idea. There are lots of regulations on the environment. There are some criminal laws on the environment. So in most countries, it's illegal to chop down trees in national parks, to release toxins into the river, to trade in protected animal species, etc. But these laws tend to be quite specific and quite technical. They often carry quite a low penalty, and they're clearly not having the preventative effect that we would like. At the international level, there's no crime of ecocide yet, as we know, and although IHL, International Humanitarian Law, protects the environment in times of armed conflict, it's quite specific in its protection, and actually there's been no cases before the International Criminal Courts of environmental war crimes. The point of having ecocide laws, either at the national or international level, is to have a single law that criminalizes these worst forms of environmental harm that cannot be justified, that is easy to understand, that covers wartime and peace, that does not require human harm, that carries a heavy sentence and therefore has this preventative effect that starts to change the way that businesses and politicians and individuals operate. So ecocide was first proposed as an international crime in 1972 by the Swedish Prime Minister. It was also one of the initial crimes being discussed for the Rome Statute, but at those times it didn't go anywhere. Then in 2020, the Stop Ecocide Foundation convened an expert panel to draft a new definition of ecocide at the international level. Kate and I were co-deputies of that panel, and it released the definition in summer 2021, which you will see on this slide here. And the hope was that with a new credible definition, then that would give the whole ecocide movement another push, at least at the international level. And I think it's fair to say that the advances over the last few years have very much exceeded our expectations, not because the expert panel published its definition. It's probably more to do with the fact that we can now feel the effects of climate change every day. We can see the fires, we can see the floods, we can see the storms on the television. And also because of the campaigns that were very effective, the school strikes, Greta Thunberg, Extinction Rebellion, etc. And so I think these factors all coalesced to create a lot of new momentum for new ecocide laws at both the national and the international level. And so in the last few years, we've seen a whole bunch of new proposals and some new laws. So there's actual laws in France, in Belgium, in a Mexican state, and of course in the EU, as we heard from Marie. There is current draft laws in Brazil, Netherlands, Mexico at the federal level, Italy, Peru, Scotland, and Ukraine. And at the international level, we now have a proposal that is put before the Assembly of State Parties at the International Criminal Court by a few states and supported by the DRC. So it's all this new momentum that has created a lot of demand for technical expertise. And the stakeholders are asking what the consequences are for businesses. How can lawmakers craft laws to fit with their national systems? How can businesses adapt to become compliant? And what's the best way for NGOs to monitor the implementation of these new laws? And so Kate and I and our colleagues, we started to get more and more requests for this type of technical advice. And I think over the years we've worked on probably most of the new laws and proposals that I mentioned before. And so Ecocide Law Advisory came from that demand that we felt, and the idea is to have a single entity that gathers the technical legal expertise under one roof. So lawyers with experience from a wide range of jurisdictions and a knowledge hub that gathers the key material to build on the lessons that we've learned so far and provide assistance that is hopefully effective and consistent and smooths the way for more adoption of laws at the national and hopefully international level, and also the implementation of those laws. So to summarize the 4 objectives of Ecocide Law Advisory are firstly to support national actors to develop and implement the Ecocide legislation at country level. Secondly, to provide advice and assistance to anyone who's interested in supporting an amendment to the Rome Statute to add ecocide as the 5th crime. Thirdly, to collaborate with international human rights institutions to see how we can use ecocide to protect human rights. And fourth, to advise CSOs and businesses on how to monitor and conform to new ecocide laws. So just to give you a few examples of the projects that we've done so far. In Brazil, we worked with civil society groups and a political party, PSL. We gave advice on ecocide laws and proposals around the world to give them a sense of what the options are. We drafted the National Ecocide Bill, adapted to the Brazilian legal system, and we provided an explanatory note so that the lawmakers could understand the parameters and the consequences of adopting such a law. And that bill was approved by the Environment and Sustainability Committees already, and it's now waiting to be voted on by the Constitution and Justice Committees. And if approved, then it will go to the full Parliament for voting. As Marie's mentioned already, we helped with her team, the European Greens, when they were pushing for amendments to the European Crimes Directive. We drafted various options of ecocide provisions to be put forward. We helped the Green Party respond to the requests for the criticisms, the concerns. And in the end, of course, the EU adopted an aggravated offence within the European Crimes Directive that is similar to an ecocide offence. And I think that's possibly the most significant development that we've had so far, because it has to be adopted by all 27 member states within 2 years. That, of course, is the subject of the manual that we will be discussing shortly, and the Ecocide Law Advisory was heavily involved in that project too. Kate?
Oh, over to me. Yeah, so I'm going to briefly jump into presenter mode just to do the little bit of the end on the Ecocide Law Advisory, just a couple of slides, because I'm more involved in the Scotland consultations at the moment, supporting the Scottish MP Monica Lennon, who is proposing an ecocide bill, the Ecocide Prevention Scotland Bill. Monica put the bill out to public consultation. They had over 3,000 responses and 95% were in support. So it's going through the paces in the Scottish Parliament, and I'm part of the advisory group for Ecocide Law Advisory on helping her craft a number of the issues. All the conversations that we had in the working group and that we'll hear about a little more in the manual, of course, have come up in the context of that as well. And just, it might be interesting to know that Scotland, of course, so it does make its own laws within the UK framework. And Scotland has as a strategic objective to stay as closely aligned as possible with the EU legal system, despite Brexit. So that's why they're particularly interested, or that gives some momentum for them to follow the European Crime Directive, even though, of course, Scotland is no longer part of the EU. Looking ahead then briefly, I think Richard's already outlined the major areas in which Ecocide Law Advisory will be working. The first one addresses the bodies we're working with. There's, of course, the working group, which some of the other members of the group are here today. Some will be online for the manual. We're looking with Lammert and others at how to move to implementation of that manual, or how to potentially expand the manual more broadly beyond the EU. We're continuing to advise on the amendment proposal to the International Criminal Court, including, for example, drafting of elements of crimes and so on, and other national laws of ecocide, which we hope there'll be more demand for that going forward. We've done quite a lot of work with international human rights mechanisms, and that looks like continuing. So just last week, we had our second meeting with a group of UN special rapporteurs on human rights to discuss how the concept of a crime of ecocide can be helpful to them, for example, in looking at the human right, of course, to a healthy environment, to a safe climate, but also to safe and clean drinking water, to shelter, to food, and so on. We've submitted a couple of briefs to special rapporteurs to consider framing their concerns about human rights and the environment and the effect on people in terms of the crime of ecocide. And we, for example, submitted a brief to the Inter-American Court on Human Rights, who have an ongoing advisory opinion proceedings in which we argued that there was actually a duty under international human rights law to criminalise ecocide, especially when that was a result of a violation of the right to life, for example. So that's a whole other area in which we're interested in working. And then finally, as Richard mentioned, there's the more academic side, or the knowledge hub. So much of that is focused on the ecocidelelaw.com website, which is a website that we co-host with Stop Ecocide International and the University of London. And there's a range of materials on that site. I'd invite you all to have a look, ecocidelelaw.com. For example, we had a symposium, an online symposium, which we published on that site. Some of the contributors to the symposium are here. We're particularly interested to include more voices from the Global South in the ecocide debate through that symposium. We're working now on a journal, a special edition of the International Journal on Human Rights, which will build off many of those papers and include some more. And we'll be having a conference for the launch of that journal as well, probably in the autumn of this year. And then you can also see on screen one of what I think is perhaps the most useful resources, which is what we think is a pretty comprehensive and annotated list of all the academic writing on international criminal law and the protection of the environment going back to the 1970s. And you see there a little screenshot of a 2024 with a couple of the more recent ones. And those summaries, the research and the summaries are done mainly by UCLA law students, but also by one University of Amsterdam student, our sister, who's sitting here in the front row and is responsible for the latest update. So please check out ecocidelelaw.com for that aspect of the work. And with that, I will step back into my hosting role. And I'm very delighted to now introduce our second distinguished keynote speaker, Professor Fausto Pocar, whom Marie already referenced in her opening remarks for his work in relation to the European Law Institute. So Fausto is a professor at the University of Milan. He's a former member of the UN Human Rights Committee. He's held a number of judicial positions in international courts, including at the International Court of Justice, the International Criminal Tribunal for Rwanda, and the International Criminal Tribunal for the former Yugoslavia, where he was also president. He led, as we heard, the European Law Institute's important work on ecocide, which issued its report in 2023. And he was, I'm very delighted to say, a member of our working group on the manual. So please join me in welcoming Professor Pocar, who will introduce us to some of the challenges around defining the crime of ecocide.
Thank you, Kate. I'm delighted to be here, to have been invited to this launch of the manual, and to do it in the Instituut. Now we were discussing. I was here the year the Asher Institute was opened, so 6 years ago. But that's a long time ago. Just a few words because the introduction has already been made, and then we'll speak of the manual in concrete terms. But my participation is limited to the manual. I started a completely different initiative within the European Law Institute. European Law Institute is an institute that makes researches that may interest the European law and the European environment, of course. And having to propose something together with a colleague that was a legal officer in the previously a legal officer in the European Parliament, Robert Bray, we decided why not to do something on ecocide, research on ecocide. The definition of the independent group appointed by Stop Ecocide has already finished its work. So we had the definition there, but in a way we thought that we needed another initiative at the European level, because we know the times of introducing a concept, a rule in international law and international legal instrument, including the Rome Statute of the Court. It takes time. You need a conference of revision. Then you need ratification by states of the novelties that have been adopted. So it takes years. And we thought the problem of ecocide is urgent in reality. It's not something you can postpone, and then you need a prosecutor to start cases. It takes a long time, actually. So we decided to do something at the European level. And how to do it was quite a problem, because initially we thought we asked for a law, for a European regulation or something on ecocide. But then we would have been in conflict with the directive of 2008 on environmental crimes that was under revision already. We started in end of 21, our work, and having this, we thought it was better to insert our work in the revision of the directive. It would have been more easy to get something. So the idea was that to say during the revision to qualify some crimes. It's a long list of crimes in the directive, not necessarily all the most serious ones, and to say that when there are certain circumstances, certain qualifications of a crime, this should be qualified crimes and be called by states ecocide. Because the directive does not say so completely. The directive says you have an aggravated crime and has to have special treatment, but as to the qualification, the denomination of the crime, as Kate has already said at the beginning, the recital in the directive says these more qualified crimes that are comparable to what some laws consider ecocide. But there is no direct recommendation to adopt the name ecocide. Why it's important, the name? The name, as a criminal lawyer, have been for too many years now, is important. It's important in the denomination of the crimes. It's not just that you make a description of conduct and then you have a penalty possible, a prosecution, the penalty. For the dissuasion, prevention activity, the denomination is important, because the stigma that a perpetrator may have in society depends also on the denomination. Saying that, for instance, just to make a simple example, ill treatment and torture. It's a difference. Being convicted for ill treatment is what? A smack, like that, is an ill treatment. But torture is torture. So everybody knows that it's a more important crime. And what we want is to work, wanted to work at the stage also of the prevention, because in particular for environmental crime, the prevention should be the priority. Because you can, of course, convict people when have committed the crimes and when they destroy the environment. But then you remain with the environment destroyed and another person in prison. That doesn't resolve any problem. The problem is to avoid, as possible, to prevent the commission of the crimes. So we worked on that, and the directive goes in that direction, maybe not as we would have wanted. Fantastic work was done in the European Parliament, of course. Marie Toussaint did an excellent work. But in a big environment like the Parliament, you have to make compromises to find a solution here and there. For instance, it's not been accepted that the most serious environmental crimes can be punished with the highest penalty in the domestic legislation. There would be life sentence. There is a minimum standard. The minimum cannot be lower than this, but there is no invitation, recommendation to go to the highest penalty, for instance. And the question of the statute of limitation is not resolved by the directive. We thought in our project that there should be no statute of limitation for the severe crimes, the severe conducts against the environment. So, but it's normal. Our was an academic work, and the academic level is easy to make proposals that maybe go beyond what when a text is adopted in a conference or in an institution. I mean, it's obvious. And this brings me also to the criminal side that was mentioned. The criminal side, it's true that in humanitarian law, there is a rule on the environment. But it's like a non-rule, in fact, because that rule is subjected to the principle of proportionality. That means that you can destroy the environment provided it is necessary to achieve your goal in the conduct of the hostilities. But this is not something that could be accepted. I mean, you can't start saying, if you need it, you can do it. It's a non-rule, in fact, and had no application. As we see, in conflicts, it has no application, de facto. So it's important to try to have that also in, maybe this is not in the directive, of course, but we can try to do it also at the level, the national level, in domestic implementation of international humanitarian law. It should be done also at the level, maybe, of the, it will be done if the definition of the is taken up by the court. It will be also in international legislation, of course. Indirectly, it will come also at the domestic level through the ratification of the Rome Statute by the states parties. So I hope we will go in that direction. We tried to do it, and although it's a fight that's not finished, of course, because first the implementation at the national levels becomes extremely important. If states take the directive at the lowest level possible, it wouldn't be a great success. The directive is a great success, but the implementation needs to be successful in order to complete the work, because the directive otherwise will not be implemented, will not have any effect, because a directive works if states implement it. Otherwise, it's like not having it. The EU will not do anything with the directive. Well, can do something, but not that much, if it is not. And of course, the problem that has been mentioned at the beginning by Marie Toussaint of the corporations is extremely important. That states first find rules that allow for the conviction of corporation, which is not in all states of the EU, because legal responsibility, criminal responsibility is normally considered individual criminal responsibility. So you can prosecute the director of a company, but not the company itself, not the whole of the company. So it's important to have that too, and the developments there. So there are a number of areas in which the work has to be done. A full implementation of the directive is quite a great endeavor to do something in many fields of the law. And this, and if it's successful, will change the world. So let's hope to do something for that. Thank you.
Thank you very much. Thank you so much, Fausto. Thank you, Professor Pocar, for that very, as usual, really bringing to life the processes, the challenges, and giving us all some insight into the struggles around not just creating and defining the laws, but moving us towards the conversation about the implementation, which is what we're moving to now. So now I'd like to invite 3 more members of the working group to join us at the panel. Ingeborg, Lammert, of course, and Lisette. First of all, I'm going to turn over to Lammert van Raan. He also got a shout out from Marie. Lammert, of course, is the former member of the Dutch Parliament who, as a member of Parliament for Partij van de Dieren, was responsible for introducing the Dutch proposed Ecocide Bill. And after Lammert's intervention, we will hear from Lisette van der Linde, who is a sustainability lawyer at De Roos Advocaten. De Roos Advocaten, you'll see, also important organisers of the manual. And Lisette was also secretary of the working group, so she is going to take us through the manual. And after that, I'm delighted to say we will close with Ingeborg Koopmans, who is a Dutch environmental crime prosecutor, also a member of the working group, and she will speak about how she and her colleagues may use the manual in practice. And then we'll move to the Q&A. So, Lammert, over to you.
So, long program. Thank you. And let me tell you how this manual came about. But first of all, congratulations to Richard and Kate for launching the Ecocide Law Initiative today. Can we have an applause, please? Okay, thank you. Thank you. Thank you. Also to be a bit of power in the room. And thank you, Marie, for her dauntless campaigning for Ecocide Law. And Fausto, where are you? There you are. Thank you for laying out the many fierce challenges the implementation is facing Ecocide Law. And many challenges indeed. So when we are at the war with nature, as we seem to be, it helps to remember Polly Higgins. I call her that gentle giant on whose shoulders we stand. And who said, imagine a law that starts from first, do no harm. That stops this dangerous game and takes us to a place of safety. And as Richard said, we have already seen examples of ecocide law across the world, including Europe, specifically in Belgium and France. And we have ambitious proposals in the UK, Scotland, and the Netherlands. And the results of these efforts, I would say, are that there's not only some sweat forming in some boardrooms already, but that the discussion on ecocide law is at a higher level, that we have advanced laws, and that's important to state. And naturally it follows that if we have these advanced laws, the objections and the challenges are also very advanced. So in other words, we really raise the level of discussion on this topic. And it's also interesting to see in this new law types that the objections of one party are the innovations of the other party. And history will decide which is which. And so we arrive at a new European Environmental Crime Directive with its opportunity for improvements, as Fausto said. And when the Dutch Council of State reviewed the Ecocide law I proposed, I was struck by how familiar these challenges and these objections were. They echoed concerns that have been voiced many times before. Issues such as unlawfulness, threshold of harm, and so on. Lisette will elaborate on these in a moment. And you don't have to be a genius, and trust me, I'm not a genius, to see that as lawmakers implement this Environmental Crime Directive, that they will run into the same challenges as we did. So, Sjoerd, Lisette, Kate, Richard and I came up with the idea of making a manual. And yes, it does exist. You have it here. It will be freely available, of course. An idea of making a manual for ambitious lawmakers about the lessons learned of making an ecocide law. And we invited top legal minds, some of which are in the room, some of which are in space, online, following us. Top legal minds to help build it, 15 of which graciously responded to the call. And it's a special kind of manual. You probably all know these IKEA manuals, where you arrive eventually at your closet that you built, probably with some screws left. It's a one-way built closet, so it's a one solution to one challenge. But our manual is different. Because since each EU country has, of course, different law systems, we structured the challenges as building blocks. And we developed solutions for these building blocks. So lawmakers across Europe can pick and choose from these building blocks and the best solutions for their particular law systems. And these solutions had to meet 3 requirements. First of all, they have to be legally sound. They have to stand up to the highest standard of legal scrutiny. And I trust you in this room to test it. I come back to that later. The second requirement that the solution has to fulfill is, does it enhance the Environmental Crime Directive? In other words, does it help to protect the environment better? And the third requirement for the solution is it feasible? Can lawmakers, but not only lawmakers, but prosecutors work with it? So, legal scrutiny, highest standard, does it enhance the ECD, and is it feasible? And the result is what we call the Manual for a National Criminalisation of Ecocide, offered freely. Before Lisette will explain more in detail the workings of the manual, I want to leave you with 2 closing remarks. First, here we go, a huge thank you to the participants of the working group, wherever you are. You really went above and beyond the call, and I applaud your creativity and your ingenuity to come up with solutions. Normally when you have 3 legal people in the room, you have 4 opinions. But here it was really, if one solution came forward, the others tried to help to make that solution better before they presented their own solution. So that's really, really wonderful. Also a big thank you to law firm De Roos for their support, and of course Ecocide Law Advisory. And a big thank you, we have to mention it, for the additional and crucial support of Agenda to make this possible. Played an important role. So to conclude, my first contribution to the Ecocide movement was to write a initiative, a paper for my council member in Amsterdam. And I thought, why stop at city limits? Why not go national? And when that was done, I thought, well, why not go Europe? Now this is done. And now, perhaps you've guessed it, let's see if we can make a global manual. Because UN Chief Inger Andersen said, we are at war with nature. We are at war with nature. Hubert Reeves, famous Canadian scientist, said, if we win, we are lost. And I say, Ecocide law, and therefore this manual, is a much needed peace initiative. and you're all invited to participate. Thank you.
I think this is better, right? So thanks, Lauren, for your inspiring words. I think my presentation will be a bit more dry. I'll walk you through the content of the manual. So I'm just gonna wait for it to pop up on the screen for a second there. Yeah, so there it is. So I'll briefly introduce myself again. My name is Lisette. I had the honor of acting as a co-secretary of the working group together with my colleague Sjoerd. So first of all, let me briefly explain the process of this working group project, which is on the next slide, actually. Oh, yeah, of course. No worries. Yeah, there it is. So after Lammert initiated the project and the working group was assembled, what we started to do was think of these building blocks, which are essential questions that come up when criminalizing ecocide. And they are the following 5. Unlawfulness, mens rea, the threshold of environmental harm, offenses of infringement versus endangerment offenses, and the issue of extraterritorial jurisdiction. And I'll come back to these in a second. After we thought up these building blocks, we had different meetings with all working group members about these subjects. Everybody contributed in different ways through online sessions, through written contributions, through some feedback rounds. And then we ended up with this draft that I think really reflects all the different views of these legal experts and compounds all the knowledge that was in this group. So, and that end result is now in the manual. So then let's move on to the content there, and it's all about the building blocks. I think that the manual really starts from the question, from the assumption that ecocide and criminalizing it is not a yes or no question. It's many questions on how to do so, and there's a lot of choices to be made and things to think about. And 5 essential elements of these are on the screen right now. So the first is unlawfulness, which really pertains to the question of what is unlawful behavior. Should we have an autonomous crime of ecocide, or should it be tied to pre-existing regulations? And then also, what role do authorizations play in that discussion? Then for the second building block, which is mens rea, which translates to criminal mind, the question is, should ecocide be a crime that is committed intentionally, or is it already ecocide if environmental harm is done in a grossly negligent way? Then the third building block that we discussed pertains to the threshold of environmental harm, which basically is about the question, when does something become ecocide-sized harm, and when is it just regular environmental harm? And then we have these three terms in the ECD, which are substantial, widespread, and long-term or irreversible, which, well, is actually 4. Do we define these terms further, and if so, how? Then the fourth building block, which is about infringement versus endangerment, is about the question of should we criminalize the doing of actual environmental damage, or should we criminalize the creation of a risk to such damage? And then the last building block that we discussed is about extraterritorial jurisdiction. And of course, environmental harm often transcends national boundaries. So should it be possible to prosecute beyond national boundaries? And if yes, on which grounds? So then a little bit about the structure. You can see a sneak peek of the manual here. We started every chapter with a short introduction about the subject, so just to warm up. And then we immediately went to how is unlawfulness or the other subjects, how are they managed in the ECD? What does it say already? Then we formulated general recommendations to keep in mind when dealing with these subjects. And lastly, but definitely most importantly, we drafted these different solutions, which Lammert already pointed out. Different paths really to choose from in the context of those subjects, and then also the implications that such an option may bring, the advantages and the disadvantages. Of course, no solution is perfect, if only it were, but already having these different options and knowing what it means to choose an option is really helpful, in my humble opinion. So, to summarize and just list the main characteristics of the manual, I think that it really structures the ecocide debate, both by having the structured manual and the 5 building blocks, and by just assembling all the knowledge and putting it in one document. Then it also offers practical guidance by, listing the options that are there. And then lastly, it draws from experience that is already anywhere in the world, international law for national developments, legal discussions, anything, which means that there's no need to reinvent the wheel. So that concludes it. I hope you're all excited to read it. The manual is already available for download, and the link is on the screen there. So yeah, that concludes what I had to say, and I'll give the floor to Ingeborg now.
Thank you, Lisette.
Thank you. Yeah, I'm a public prosecutor, and I've been prosecuting environmental crimes in the Netherlands for the last 25 years. And I've been looking forward to, the Ecocide law. Actually, I wrote my dissertation on it in 1996, and I already proposed an independent statute which sort of looked like Ecocide. So I had to wait 30 years until it finally is there. If you could put up my presentation, thanks. Because finally we have like a broadened perspective, and it's needed, especially in current times. And why is that? Because most of environmental law and thus environmental crimes are depending on political decision making. And as we can see, the political decision making in general is, well, from my perspective, going the wrong way, which basically means that instead of protecting the environment better than we've done, it's going the other way. People are not really making an effort. Right now, the environment, or at least when you look at our criminal law, is only protected when it comes to human health. And even when human health is at stake, our politicians often say, well, we need another research, or we need another report before they actually do something and stop the environmental harm being done, even though human health is at stake. So when you look at our current laws, it's basically public welfare law, which means people are not taking it as serious as they should. A consequence is that we see that supervision on companies and people abiding the law is negotiable. It's not really forbidden. You can also always negotiate whether it's forbidden or not. We have a poor information position. We don't know exactly what's going on. We have a lower chance of catching the criminals. The sanctions that are imposed if we succeed in prosecution are too low to be deterrent. And in the end, it's an unfair competition. There's no level playing field. So it's not people who do care and stay on the right side of the law actually pay the consequences instead of that they get a reward for it. It leads to dissatisfied citizens. The last couple of years, what we see is because our politicians are not taking up the action that's needed, people come to the public prosecutor's office and they want us to do whatever, but basically that means that we're working on individual cases that people bring to us instead of making our own choices and sometimes prosecute corporations. And well, a lot of that is a consequence of unreliable government at this particular moment. Which leads to subversion, because it undermines, well, basically my job and doing what we do. So I welcome the EU directive, and I've already seen the draft that's from our Department of Justice, how we want to implement it in Dutch law. And there's always, you can always have some comments on it and say, well, this is not good and that's not good. But I'm pretty happy with it, and we have an opportunity to make some changes, so we are working on that from the Public Prosecutor's Office. But the most important thing is that it's constitute a provision that directly criminalizes environmental pollution. And well, basically that's the ecocentric concept, and we call it ecocide nowadays, but I used to call it the ecocentric concept in my dissertation. The advantages are that we have direct protection of the environment and environmental values like air, water, soil, biodiversity. We can directly protect that. We don't have to care about whether it's influencing human health or individuals. If the environment is harmed, we can actually do something. It's independent of administrative political decision making, which will be so relieving. I cannot begin to start saying how much relieving that is. It's becoming a serious criminal offense to harm the environment, to harm water, air, soil, biodiversity, which will deter people. People are going to think about, wait a minute, if I face 10 or 15 years instead of 10 or 15 months, or maybe only a fine, things will change. The EU directive already says that we need effective, proportionate, and dissuasive sanctions. Well, finally, we're going to get them because we need them in the statutes in order to be able to ask for them in court. It will contribute to a much more level playing field because it will reward companies and people that are actually concerned about the environment. And I hope it will reduce externalization of environmental effects, because that in the end is our main goal. There are a couple of things about the manual that are interesting to talk about, but I picked two because those, for me, are the most important ones. And the first question is whether or not you want endangerment or infringement offenses. I want them both, because it's very simple. I want to criminalize the risk, but I also want to get the one who did it and finally polluted the environment. But as Professor Pocar said, criminalizing the risk is more important because we want to prevent it from happening. So yes, I want them both. And especially also because environmental pollution goes slow and undiscovered. And that makes it a lot harder to do something about it. And then the principle of legality, everybody always says it's too vague. You can't do it. And I'm like, well, yeah, you can. You just have to try and do it. Because the only way to get this problem solved is by bringing it to the judge and let the judge decide where the boundaries are. And that's the only way we can achieve something and get there. So we're going to try cases, and we're going to ask the judge to set the boundaries. Or at least that's my intention for the next 10 years. That's what I wanted to share with you. Thank you.
Thank you. Okay, so you can see how great it was to have these people in a working group, right? I mean, it was a lot of fun, and you'll find a lot of the things that you're hearing from the participants reflected in the manual, which, as Lisette said, you can find on ecocidelawadvisory.com. But now we're moving to the Q&A portion of the event. So in addition to the people who've already spoken, we have some other members of the working group. We have, I think, Michel Fall in the room somewhere. And we have a few people online. If we could switch to having our online participants so that they can also answer any questions, because there were a lot of us in the working group, so many people have something to contribute. So yes, does anybody want to kick off with questions? Yeah, there's one over here, thank you. Oh, and one here. Yeah.
Hi.
We also have some questions coming in online, by the way, that we'll read out too. Yes, please, do you want to introduce yourself?
Yes, I'm Michelle from Greenpeace International, Senior Legal Counsel for Litigation. I'm really thankful for the presentations, and I'm so happy I came here. Super interesting. And my question is for Dr. Koopmans. Thank you so much for your presentation. It's also very interesting and exciting to see your perspective. My question is about the extraterritoriality issue and whether it's transboundary harm. And what are your thoughts regarding, let's say, jurisdiction over the person? Let's say it's a company established here, perhaps some of the conduct is here, but the harm is done outside of the borders of the Netherlands. And how would you see that playing out with existing Dutch legislation on standing, jurisdiction, et cetera? Thank you.
I don't think that it's so much of a legal problem, because especially when part of the offense is actually done in the Netherlands. We probably have enough to start a case. The biggest problem is to get the evidence from the crime scene, because especially when it comes to like African countries or some Asian countries, it's really difficult because there's no there are no treaties or not enough treaties. It's hard to get there. It's hard to get the information you need to prove your case in court. So for me, it's much more on the practical side than on the legal side.
Yeah. Would you like to, Please. Yeah, can we have a microphone over here? Thank you.
Especially with complicity, aiding and abetting. Because one of the big issues, especially with multinational corporations, is that they produce products for sale that derive from environmental harm. The destruction of the Brazilian forest is done for cultivations that produce certain products that are sold here in Europe by the corporations. So is this aiding and abetting, selling the products here or not? I don't say the consumers aiding and abettors, it would be too much, but the corporation doing it and favoring the destruction of the environment there must have some responsibility. I think it's not always easy to prove. Of course, that's the task. I don't envy you as a prosecutor to prove it, but it's one of the problems actually, which is sort of indirect participation, indirect responsibility, but can go under aiding and abetting. So it's just putting the question.
Yeah. Yeah, we have the number. I should just say that there's a very interesting chapter in the manual, because the ECD actually has quite an extensive range of potential bases for extraterritorial jurisdiction. So we tried to examine some of those in the manual. I just want to say we also have Herman Ott online, who's a panel member, I see. Hello, Herman. And Marie's had to go into the debate, but her assistant Roxanne is available apparently to answer questions as well on behalf of Marie. So I think we had a question from Wouter. Any more questions so I can gather them? And then another one in the front row here. Second row here. Thank you.
I'm Wouter Vening with the Instituut for Environmental Security, also based in The Hague. Compliments for the efforts and for the production of this manual, everybody who was involved. Many, many compliments. I was wondering, what is the relationship with, how does the manual see the relationship between the Rome Statute and the Environmental Crime Directive of the EU? And also, do you make an explicit difference between war situations and non-war situations? As Institute for Environmental Security, we are very much focused also on war situations and the relevance of the A2 before war crimes article in the Rome Statute. How does the manual relate to these two issues? Thank you. Compliments again.
Thank you. Let's maybe take the other question. And it's just here.
Hi. I actually have two questions. But I'm Anna Saramona. I'm a law student at Utrecht University and a member of Stop Ecocide Netherlands. My first question is for the Ecocide Law Advisory. I'm actually student assistant for the Ecocide Knowledge Hub in Utrecht. You're, as I learned now, named partners. I was wondering whether you're gonna work together with them in any ways. Yeah, what are your thoughts on that? And then my second question is about the manual, which I'm very curious to read, and I think a lot of law students will jump on the opportunity to write thesis and projects in any way. So I think it's the ECD, I've read it many times. I think there's a lot of very novel things inside, like the unlawfulness definition. But there's one thing that I'm trying to grasp fully, like the novelty of it, and that's the qualified offense. Because the way I read it, it doesn't really extend the scope so much of what an environmental crime is. And it seems to me that it's quite similar to an aggravated circumstance in criminal law. I'm just really interested to hear thoughts on people that have been working on the manual, on how you think about that. Thanks.
Thank you. Who would like to? Short, I wondered if you might want to answer a question just to introduce Short, who's also a panel member in the room. Did you want to come in on any of those?
Maybe one of the next ones.
Okay, absolutely fine. Fausto, would you be interested to answer any of those ones? Yeah. Yeah. Well, I think on the qualified offence, I can maybe. Do you want to answer, Richard? Go ahead. Yeah, go ahead. No.
Yeah, what the ECD does, it doesn't expand the scope of environmental offences because it has to tie, the qualified offence is tied to the other environmental offences that already exist in EU legislation. And as I understand it, I'm not an expert in EU law, but I was told that you can't expand within a directive, you can't create new crimes, but you can create new penalties. So what it does, it basically says that if any of the crimes listed above cause more serious harm, then there will be greater penalties. And it's very similar to Ecocide. It's just that it had to be tied to this long list of other environmental crimes that already existed. On the question of war crimes, it doesn't really relate to war crimes, this directive. This is really talking about domestic types of crimes and regulations. It's not dealing with armed conflict. And in many ways it doesn't need to, because all those EU member states are already signed up to the Rome Statute, so they already have international humanitarian law within their domestic system, which already covers many forms of environmental crime in times of armed conflict.
And I can say on cooperating with the Utrecht programme, absolutely, we're in touch already and are always happy to collaborate, especially on developing knowledge. Yeah. Please, yeah. Could we have the microphone?
Mm-hmm. Sorry, the problem with the war crime in the statute is that the definition of the crime derives from a rule in the protocol of the Geneva Conventions, and the first protocol, because there are no crimes so it applies only in international conflicts. There's no application in domestic conflicts. First, so it's just a limitation. Clearly, it's not been extended in the statute to the. It could be extended de facto through the case law, but that you need very progressive case law to do that. I mean, because you can say that what is it in international conflicts applies also in domestic conflicts. We had the discussion on the ICTY as long as the beginning of the ICTY. But the text is not taking exactly what is in the protocol, but is watering it down a bit. That's the real problem. I mean, and one should find the principle of proportionality is put differently. So, as I said before, you can cause damage to the environment if it is necessary to achieve your goal in hostilities. If it is not necessary, but normally a state would not, a combatant would not destroy the environment just to destroy it. It's because it thinks it's useful. So at the end, it's very difficult to find a solution for this problem. And one should probably try also to work on the statute, on the Rome statute, and change the rule. There are some have written on that. There is an American Drumble, Professor Drumble has written on that, and we are on the same line that we should go back to the protocol in the definition.
Thank you. Lammert, you wanted to come in?
Yeah, just shortly on the point Wouter asked on the relationship between the Statute of Rome and this, for instance, this manual or the ECD. Apart from the legal, I would say the legal details and the legal framework, I think the most important point I can illustrate by telling you about the response the Dutch government gave to the Dutch initiative law. And they said, well, ecocide, nobody knows what it is. I mean, I'm paraphrasing a bit, but it's too vague. And I think it's exactly stuff like Fausto said, when you define the name, work on the ECD, on this manual, you start seeing that the term is becoming established. And I think that's one of the most important things, apart from the legal framework, which we can discuss, of course. And on the Utrecht question again, Professor Cedric Reynard is organizing a clinic around this manual to have students stress test, find holes in it. So there's a big participation already. Yeah. Thank you.
Oh, look at that. Whoa. We've got one at the back, 2, 3, 4 we could start with.
Thank you for the presentation. It was very interesting. I have a question regarding the ECD. Do you know what is the current state regarding the civil liability? Like, will the member states have to ensure civil liability as well, or is it only governmental connected?
Thank you. Next question.
I will stand up so I can see you. My name is Myra. I also have a background in law, but at the same time, I also represent the indigenous voices. So that's the reason why I'm very excited to hear that we have such an advisory this launch, and also the manual. And my question is mostly about related to inclusivity in terms of the process, and also not only in the process but in the decision making, because as we all know, or most of us know, 80% of biodiversity worldwide is taken care by indigenous communities. but nowhere are we really mentioned, even in today's discussion. Nor I don't know how far we involved in the process of making the manual. But my question is like, is there a space for indigenous communities or indigenous leaders or indigenous voices to be part of the process? Also, when it comes to moving forward here in Europe. Thank you.
Thank you. Thank you. Should we take, and there was another one in the middle somewhere.
Thank you so much for the presentation. My name is Nicholas Klaassen. I'm a student at the University of Amsterdam for International Criminal Law. And my question would be kind of what are the perspectives for Ecocide to directly address not environmental damage, but climate damage, basically, so overly excessive emission of greenhouse gases, because I still, even though they are actively harmful, I couldn't see how the large emission of greenhouse gas like carbon dioxide, methane, something like that, could fit under a definition of a risk of causing widespread or severe environmental harm. And I wanted to ask whether you think that there is a perspective for Ecocide to address that, or is there maybe another need to address that, for example, through economic crime, like fraud in the emission trading system or something like that, if that would be a better alternative? Thank you.
Thank you. Another great question. Should we just take one more and then try and answer them?
Yeah, I have the mic.
Oh, okay. Kidnap the microphone.
Should
it's
I?
fine. Go ahead. Yeah.
Yeah, okay. Yeah, thank you for the presentation. I'm Alexandre, and I work as a youth coordinator in the European Parliament, but I'm also in the core member team of Youth for Ecocide Law. Yeah, so my question was related a little bit to the rights of nature movement and its interplay with Ecocide. So for like, let's say from an enforceability approach, because I'm thinking now of like prosecuting environmental crimes once an Ecocide law is in there. Yeah, what do you see is the interplay or maybe the advantages or disadvantages from this approach? So for example, I come from Spain, and there the Alacún de Mar Menor was given a legal personality, let's say, in 2022, and it made a major difference to actually, for prosecutors there to be able to protect it and be faster. But yeah, I don't know about the reality in other member states, or maybe if we actually could even move it at the regional, so the European level or the international level. So yeah, I wanted to know your opinion on that.
Thank you. Okay. Ingeborg, do you have any reflections on how rights of nature in the Netherlands? The last question.
I think it would help if we had, well, if environmental parks or rivers or whatever have rights and can stand up for themselves. But again, I'll be practical. I need a lot of hands to make the bet, and I don't have so many hands. So that's our biggest problem. We need people, we need money, we need judges in order to be able to bring our cases to court. But it would help because they would be able to come forward themselves instead of through an NGO or any other group. So yeah, I'm a big fan of the movement, so yeah.
Thank you, and I'm delighted to see that Herman has his hand up. Herman, would you like to answer some of those questions? Welcome.
Yes, thanks. Great question. And I would say that they are two separate movements, Ecocide and rights of nature. But they run on fairly parallel tracks, and they mutually reinforce each other. So all those who are actually interested in bringing forward the Ecocide, actually I would say please do get interested in rights of nature, because getting away from this anthropocentric view of law and environmental crimes is an important part also of this. And it changed the minds of people who are actually being confronted either with rights of nature or ecocide. Thanks for this question.
Thank you, Herman. Anybody want to answer the question on space for indigenous voices or on the climate issue? Lammert?
Always want to answer questions. On the rights of nature, I see it as two sides of the same coin. The coin being keep the planet alive, so rights of nature and ecocide, two sides, same coin. On the indigenous question, yes, of course. I'm speaking for myself. It's been the inspiration for ecocide law to get the Sorry, I promised I would not say it. To get the bastards in jail, because the way indigenous peoples handle nature is something we can learn so much from. We forgot about it. And what you also see is that the challenge, of course, is to get indigenous perspectives which are far richer and far more, I would say, stable than you can put in a law text. That we really need that knowledge to reflect in the law text. And that is always a challenge, because when you look at how indigenous peoples guard nature, they don't do it by law. They do it by their knowledge and their knowledge of nature and their ancestors and the way how they view the world. So we really have to learn and watch, how we can translate that into, I would say, global North law. That is really the challenge, but we have to do it.
Can I add on to that? I would like to actually invite a very concrete meeting, because this manual, this is a first. It was pretty quick, actually, that we pulled this together, because, as you heard from Ingeborg, the Dutch are already drafting their law. So we pulled this together pretty quickly. I think we explore a load of options, but I think it would be actually very interesting to have a specific consultation with indigenous lawyers and legal thinkers around this, and to look at whether we need to amend and in which ways this responds to those inputs. So I would offer you an invitation really to please let's connect about that and see if we can move it forward. Yeah, thank you.
Yep.
Thank you. Yeah. Yeah. What about the climate question? That was a great question. Anybody want to answer? Anybody want to answer that one? No?
Yeah.
Ingeborg?
Oh, the interesting thing about that question is that most countries have set climate goals. And I've been sort of trying to get the Public Prosecutor's Office to think about how we can set in our, people and resources in order to reach those climate goals. So maybe it would be, and it's kind of hard because you always have people who think differently, so it's like a discussion and a debate within the Public Prosecutor's Office. How we could set out a program and make priorities in order to reach the climate goals that our government has set, like the reduction of CO2 by 2030 or 2035. But it's really difficult to get the hands together for that. But I'm trying to do it, and I'll keep doing it. And you never know. Maybe it changes. I mean, I waited 30 years and it changed anyway, so hey.
Yeah, could we have the microphone out? Maybe I could just add on to the end of that one as well, because I think while it's difficult, it's more difficult to understand how an ecocide law can capture climate harm. I mean, deforestation probably not, right? But emissions, yes. More difficult than deforestation or pollution or something that's easier to grasp. But I think even since we started discussing this, I feel like that's already moved. So we've already had the advisory opinion of the International Tribunal on the Law of the Sea, which says that greenhouse gas emissions equals pollution, for example. So that's already suggesting a pathway in which, you know, regulation of greenhouse gas emissions might be a bit more straightforward, and there might be a way to penalise or quantify. The developments in attribution science have also been remarkable in that period. So while I think it's still not exactly clear how an ecocide law could capture those kind of, you know, emissions-related climate harms, I think we can see that it probably will become clear in the not too distant future. That would be my contribution on that. Please.
Yeah, it's an excellent question to see whether climate change or, you know, can be qualified as ecocide. And I think it's a very valid question because you can probably answer it affirmative. CO2 remains for hundreds of years, you know, in the atmosphere, so it is long term. A CO2 molecule emitted here has its effect on the Pacific Islands at the other side of the world, so it's widespread. If you see the fires now in Los Angeles, if you see the impact of hurricanes and of storms, many places in the world, if you see the droughts in Africa, you know, and the violence associated with the droughts in Africa, you know, it all criteria for ecocide, it qualifies, very much so. The advisory opinion of the International Court of Justice is useful, but it is not criminal justice which is being advised there, because they are advising on the Climate Change Convention. And the criminal justice aspects of the Climate Change Convention are extremely weak, almost non-existent. So if you want to do something from the criminal law perspective on climate change, you know, qualifying it as ecocide and applying the recommendations and the advisory opinions which are contained in your manual will be extremely relevant.
Thank you. We had still the question about civil liability under the ECD. Maybe I can just say briefly, I believe it's just the Environmental Crime Directive, so it just deals with criminal regulation. Does that answer the question? Yeah. Okay, any more questions? We have some over here. At the front here. I think we have maybe 3. Yeah.
Okay, I'm standing up also because I can't see everybody from here. My question actually, before I start, hats off to the launch, the manual, advisory, and the advisory, what is it again? Ecocide Law Advisory, yeah. ELA, yeah. That's right. My name is Shalene Chin, Green Transparency, a consultant of sorts. I was struck actually by Judge Pocar's remark about the progression on getting there to ecocide in your work with Robert Bray. You mentioned whether or not we could get also a regulation if the ECD, the implementation of the ECD is not as effective as we thought. And I'm brought back to an initiative that Wouter and I collaborated with Polly in 2012, 2013, and it's called the European Citizens Initiative. And I just want to get your thoughts on whether or not we should reinitiate this initiative, because it may be something that we would like to restart. In short, the European Citizens Initiative is pretty much a grassroots or democratic way of involving European citizens in proposing a legislation. And if one can gather 1 million signatures across at least 7 member states, EU member states, then the EU would have to seriously consider putting in, or at least consider a regulation on ecocide. That would, if not raise, I guess, the concept of ecocide even higher than a directive alone, where the directive is, you know, is dependent on the transposition in each member state. So it's maybe a thought from the panel. Thank you.
Thank you. I think there was another question at the front. Oh, sorry, go ahead. Yeah, yeah.
Hi, thank you. My name is Melody. I'm an exchange student coming from McGill University in Canada. So thank you very much for the presentation and for making it so accessible. My question is about the manual seemed to outline that it was providing building blocks for lawmakers rather than doing like a one-size-all approach. And I was just wondering about how do you connect or synthesize this, what seems to be domestic law, with the broader European law, and whether you anticipate any challenges between working with what individual countries and lawmakers come up with the broader European regulations on ecocide.
Thank you. And then one more at the front.
Hi, I'm Margot Verbaarschot, working for the Dutch police. And I'm a little bit worried, but you might help me with that. Maybe my worries are for nothing. About the gap there might be between the legal gain you have from prosecuting criminal environmental crime and the ecological gain. Like a lot of times it already happened and then the harm is done. Is there more we can do about the ecological side?
Thank you. Richard, do you want to start?
Well, I can just say a few words about the last question. I think certainly at the international level, so the idea of having a fifth crime in the ICC, I think the greatest value of that is the symbolic power to put ecocide at the same level as genocide or war crimes or crimes against humanity. And by doing that, it will have a deterrent effect, because business people don't want to be accused of being somehow equivalent to a war criminal. So I think, and then you compare that to what the ICC could do with its limited resources. It's only ever going to try a few cases of ecocide at best. So really, this is about sending a message to people that it's not acceptable to destroy nature without justification. And I think that's what we want to do. Certainly at the international level, I think it applies also to the national level.
I was very excited to see that Marie is back with her hand up, so I'd love, Marie, for you to come in and answer anything. Oh, hello.
Sorry for the disappointment. This is Roxane from Marie Toussaint office. If I may, I wanted to answer the first question, maybe because we discussed about that during the negotiation, the fact that we would need to go further and to have a regulation instead of a directive, also to avoid any different interpretation of the text in member states' national legislation. And unfortunately, what the legal service told us directly when we tabled the amendment on that is that it's impossible regarding the treaties. So you can refer to the Article 83 of the TFU. And there are two paragraphs. The first paragraph is regarding very important crimes, important considering the treaties. And there is no environmental crimes on this first paragraph. And so we cannot use this to go further and to have more harmonized sanctions, for example, and to have also a regulation. That was the reason why we couldn't change the directive as a regulation, but we tried to push also like aside of negotiation for a revision of the treaties in order to include environmental crime also in this first paragraph of the treaty. This is still ongoing. We had a official position from the Parliament to say that we need to include environmental crime also among this list of serious crimes. But there is no modification of the treaties for now. But yeah. If there is an initiative from citizens, it's also very good, and it could help the debate within the Parliament, I guess. But for the moment, this is like more a legal question that we need to solve. Voilà. Thanks a lot.
Fantastic, thank you. Very helpful answer to both questions. We had Melody's question about the discrepancy between potentially national laws and the directive. Does anybody want to talk about that? Short. I'm desperate to get Short to answer a question. There you are. You can answer that one.
I just left the room, actually, so I wasn't there for the question. Maybe one of you want to answer it. And then
the question was whether we foresee difficulties between the all the various national jurisdictions and the broad brush of the directive?
Not really. We all have the minimum requirements from the ECD, of course. All the countries will have that. So I don't foresee any big troubles there. But maybe Ingeborg, it's very interesting to hear from you whether in cooperating with other prosecutors you see any trouble there.
Well, I don't talk to many prosecutors from abroad, but the one thing that I do see though is that there's a difference between the European Union member states, and when I look to the Netherlands, well, in a way we are ahead because we have this separate prosecutor's office that only prosecutes environmental crimes. Most of my colleagues in the other member states are just general prosecutors who do the environmental crime on a Friday afternoon, like after like 4 o'clock, because they have like an hour left. Same goes for police officers and other investigators. They are, you know, the regular crime goes first, and then you have like, when you have, it's like almost a hobby in a lot of member states. So from that perspective, I think it's very good that the EU directive sets minimum standards and pushes for higher sanctions, because that makes that countries really need to make an effort to start doing a little bit more than they're doing. But on the other hand, even though we have a special prosecutor's office, we do have special police teams and investigative teams to investigate crimes, environmental crimes, and prosecute them. Even though we have all that, we still struggle. So that it's all about money. How much money do you want to spend on your prosecuting office in order to prevent these crimes from happening?
Thank you. I have actually got a number of questions online, which I should really turn to because we have about 4 minutes left. So there's one for you, Ingeborg. Back to you. Francesca Loci asks about the threshold of environmental harm. The manual actually sets down 4 alternative criteria to define whether the harm is substantial, but they still look somehow vague. I wonder how these criteria will be applied by the judges and if their broad interpretation may raise issues in terms of legal certainty. Well, I think you touched on that earlier.
Well, it starts with us. We need to make our definition and agree on where our boundaries are. And I'm currently involved in a few of the big cases. And it's hard, but you have to try. Somewhere you have to just start. So at some point at the prosecutor's office, we will say, well, this is meeting the threshold of ecocide, or, well, comes close to it. And have the arguments ready, and then just put them out there and let the judge decide whether or not we're right. We have to try, because if we don't, we'll never make a step.
Thank you. I have a question from Francesca Ricci relating to the challenges of implementing ecocide laws, particularly in regions with weaker legal and regulatory frameworks. What strategies could be adopted to ensure the effective implementation and enforcement of ecocide laws in these areas? And additionally, how can international cooperation be enhanced to support these efforts? I know we've got somebody in the room who I saw coming in who would have a lot to say, I'm sure, on this topic about international cooperation in prosecuting Reinhold. I don't know if you feel like jumping in at this point. I can't see where he's sitting. Yes, please, please, share your thoughts. Answer any questions you like, Reinhold, please.
Yeah, but you say there's 4 minutes left. I'm not sure. Yeah, I'm a prosecutor myself, and I've been thinking about questions about how to use criminal enforcement to support actually enforcement, because what I see is, to some extent, there is a legislative gap, but in my view, there is much more an enforcement gap, and that is because a lot of these crimes are transnational, and also, as Ingeborg says, prosecutors do not always have the capacity, the resources, and the support that they need to enforce these crimes effectively, right? So in my free time, I've set up an NGO to do exactly that, to use networks, to cooperate with specialized agencies that use data science, remote sensing, environmental scientists to collect the evidence, analyze it, and make it available to the prosecutors in an actionable format. Because in the Friday afternoon, in that 1 hour, you don't have the time to do that investigation. And that is actually, in very short, it's my suggestion forward. We need to build new alliances with experts, with CSOs, with technology experts who previously have not worked in the realm of law enforcement, need to bring them in effectively. That's the only way to do it.
Thank you so much. And Reinhold's organisation, Centre for Climate Crimes Analysis, is really doing amazing work. Okay, well, it's 6 o'clock, so I do have a couple more questions online, but I'm going to suggest that we wrap up here and move to the reception, to which you're all cordially invited. And please feel free to continue posing your questions and discussing. I want to thank the Usher Institute very much for their partnership in organising the event today, and to all of you for coming. Thank you.